This is You and the Law on AM 650. Now back to the show.
Red Robinson and the Diner coming up in just a very few minutes. I'm Sterling Fox with Scott Stanley and Kevin Gourlay from Murphy Batista LLP in studio. Murphy Batista, a Vancouver law firm that fights insurance companies on behalf of individuals. One insurance company that you're taking particular interest in these days, gentlemen, is ICBC. In fact, your firm has purchased advertising time on our airwaves to make a point about ICBC and the recent tendencies of government to raid their coffers. Give us a little background, Scott, on why you decided to purchase some ad time and bring this to the attention of listeners.
Well, our firm doesn't advertise, but we will pay for public notices that we think people need to hear about.
Okay.
And so what's going on with, firstly, I've represented about 12 or 13 insurance companies before I saw the light and started doing God's work.
Okay.
And ICBC being one of them. And just dealing with ICBC now as an opponent, it is by far, in a way, the most well-run insurance company I've ever run across.
Okay.
It is cash flow positive. It makes lots of money. And what has happened in the last years is the government, and if you take into account what they're going to do this year, they're going to remove about $1 billion worth of money from ICBC. That was meant to compensate accident victims, promote road safety, keep premiums low, and pay the people that work at ICBC.
Okay.
And that money's being removed by government. ICBC is an incredibly well-run insurance company. They're good to deal with, and government just needs to leave it alone.
And why is government are they simply taking the money from the ICBC kitty and putting it into general revenue so their debt or deficit doesn't look as bad? Is that just to offset debt? Is that what it is?
Exactly. Yep. It's been put into the general coffers.
Okay, so a cash cow.
Yep.
Being raided by the government. And how does that adversely affect ICBC from the point of view of the motorist with an insurance policy?
Well, what it does is people are always concerned when the rates go up. No one likes to pay more bills, whether it's Hydro, whether it's ICBC. And at the same time, the government's taking money from ICBC. ICBC's going to the Utility Commission trying to get their rates increased. Yeah. And it's unnecessary because there's plenty of money there. People don't know that. And ICBC, well, not, in the government, they turn around and say, well, it's the cost of claims that are going up. Well, it's actually not ICBC that says that. It's the government.
Sure, of course.
It's the cost of claims that's going up. That's what the problem is. That's why ICBC has no money. And that's not true at all. In the last couple of years, the amount of claims per year has dropped from about 30,000 to 20,000. So people are driving more safely. Roads are safer. And the reason that is, Sterling, is because we have a fault system which discourages it. It creates financial disincentives to drive poorly and unsafely. Mm-hmm. There's been a marked cessation in drunk driving. There's been a marked increase in seatbelt usage, in large part because of ICBC's safety initiatives.
Right. So we're smarter, and as a result, ICBC is paying out less in claims.
They're doing a good job managing the safety of our roads.
And with all of those excess monies that could really keep our premiums at least where they are now, if not drop them, government doesn't give us that break. They just grab the loot and use it to offset the debt.
Well, the other thing that ICBC does that a lot of people don't know is that they don't just pay for road safety awareness. They'll actually pay and contribute to capital improvements to make certain problem areas safer. A private insurance company would never do that. So, ICBC is our opponent, and they probably regard us as their opponent. But there's certainly, from our point of view, there is respect there.
Right.
Because they, in my view, they do the right thing, and government ought to just let them continue to do the right thing.
Kevin, as the new dad in this conversation, I want to go back to something we talked about a few minutes ago, and that's the whole matter of statute of limitations. Basically, in an injury-type claim against an insurance company, you've got 2 years. The exception is always children. Tell us about that.
Well, the statute of limitations is 2 years basically from the date of the accident. But for a child, that 2 years doesn't begin to run until they turn 19. It doesn't begin to run against anybody who's under a disability. So there are cases when the statute of limitations can be longer, and generally speaking, a child has until they're 21 to bring a tort claim against the other driver, or a negligence claim. they still have to advise ICBC about their claim for their own coverage under what they call Part 7, and that's for rehab benefits, physiotherapy, things like that. But they have 2 years from the 2 years that they would have from the date of the accident to bring a negligence claim against the person responsible. That's delayed until they're 19.
And why would they do that, Scott? Why would they make an exception for little people?
Well, because depending upon their situation, Sterling, that little person may not be in a home where the parents have the ability to look after their interests. So they postpone it. Because they're infants, they just can't make a decision for themselves.
Right.
But the thing that I find problematic is that although the tort claim is put off until they're 21, the Part 7 claim or the claim for benefits that they have against ICBC is not. They don't run parallel with one another. And a lot of little kiddies that we represent that come to us years after the accident, they've already lost their right for these accident benefits because that limitation has expired. So it's the limitation for accident benefits is 2 years from the date of the accident or the date ICBC last pays a benefit, whatever's longer.
Mm-hmm.
So that's what I find problematic. The two should match, really.
This term has come up a few times in the conversation, so here's my official dumb question of the day, guys. What is a tort claim?
A tort, also known as a negligence claim, is simply when a civil wrong, when you are injured by somebody else's negligent act, the claim you bring against them is called a tort claim. To succeed in a tort claim, you have to show that somebody else was negligent, that their negligence caused your injury, and then you're entitled to compensation for that injury.
Do you want to know the really groovy thing about the tort system, Sterling?
All right, sure.
It doesn't require politicians to do anything.
Oh.
It's always there to protect us, to keep us safe, to impugn unreasonable or unsafe conduct. It's not a body of written law. It's the common law that we acquired from the UK, and it's always there to protect us.
What about payouts? We hear, I mean, they're obvious. The stories that make page one are, so-and-so was damaged or hurt in an accident and was awarded $100 million. But do we have limitations in Canada, in British Columbia, on amounts that can be paid to people under insurance claims?
You don't have amounts on the total. So, for example, when you hear about the big claims, when you hear about millions of dollars being paid out, that's for people that have been very severely injured and will need millions of dollars to be cared for the rest of their lives.
Fair enough.
Or for people that were earning a lot of money before the accident and now are unable to earn income. There are caps on what you're entitled to for pain and suffering. So you don't see millions of dollars being awarded for pain and suffering, but when people are catastrophically injured, there can be millions of dollars at issue for care and for wage loss.
Sterling, the cap for pain and suffering or loss of enjoyment of life is $100,000 in 1979 dollars, but adjusted for inflation. And it's presently about $352,000. So that's the most you can get if you're a severe spinal cord patient, a severe brain injury, which isn't a lot of money.
Now, would that be from a workplace injury or a car accident? It doesn't matter the nature of the industry. That's the ceiling that you can claim for in terms of personal injury?
Well, there's no claims that arise from workplace industries, but if you've been injured in a car accident or by a doctor who was negligent or a slip and fall accident or a police officer that assaulted you, that's the limit for pain and suffering, $352,000. It goes up every year. It actually goes up every day, but that's where it is now.
And the reason for that is why?
Well, in 1979, the insurance industry convinced our Supreme Court of Canada that if we didn't have a cap, there would be a catastrophic, there would be an insurance dilemma. We would have claims go out of control. Insurance would become unaffordable. People wouldn't have coverage. And so the Supreme Court of Canada thought that it was fit to put a cap on that so that we wouldn't have increasing and rising insurance costs.
Interesting stuff. I'm afraid we're almost out of time, gentlemen. It's been another one of those 10-minute hours. Just absolutely zoom by your fascinating guests, and it's been a wonderful conversation. I thank you for your valuable time on a Sunday morning. Tell us, Scott, about Murphy Batista online, please.
Yeah, our firm's presence online is murphybatista.com. And that's BATTISTA.com. And anything that anyone wants to know about the firm is there.
And if you've been listening to the program and hearing, for example, things that have touched on your life or people in your life that maybe have had some issues with insurance companies in the past, check them out. Check them out online, murphybatista.com, and all the other contact follow-up points are right there. Scott Stanley and Kevin Gourlay, thank you, gentlemen. Great to see you.
Thanks for having us.
Thanks for having us.
I'm Sterling Fox. The Redhead is next on AM 650.